Hey everyone, Harry here to talk about Jack Smith's redaction motion and the upcoming battle over redactions in the January 6th case. Okay, so by the normal, already in place scheduling order, the parties need to address, after they've made a filing, redactions. And they are allowed to, indeed are supposed to do, certain redactions. And that means that even if the 180-page motion of Jack Smith, where he tries to march through the indictment and explain what isn't immunized and why his superseding indictment still holds, he's filed a redacted version of that memo. So the whole thing is under seal. But what is under seal? A redacted version with redactions, and now by operation of the scheduling order, the parties fight about what should be redacted. Because the important point here, and reflected in the previous scheduling order, is there's a general presumption in the law for the people and for a First Amendment right to see filings, and there is law that precedes USA versus Trump and immunity on when that presumption is overcome and when you can redact material that is part of a public filing. Now, here we learn in this redaction, there are actually two filings here. The already big 180-page motion that argues what should be immune and what shouldn't be, mainly what shouldn't be. And we can only guess some huge appendix that puts all kinds of source materials in there. And the United States has proposed treating them differently. So the most important point here is that the United States says, basically, we're gonna have everything open and concede or believe that it doesn't fit the standard for redaction in our main 180-page brief, except for, there's a few things, but the most important thing is the names of witnesses, yet only the witnesses who are not already named in the superseding indictment. The argument about redactions, in other words, is largely about protecting the identity of witnesses who could be harassed, intimidated, or even attacked by the Trump faithful if their identities were known. Everything else they're saying comes out from under seal. And here's our 180-page brief that you let us file the oversize, and has redactions, but not all that much. And in particular, we have summaries of grand jury testimony there. We're not trying to redact it. Summaries of witness interviews, we're not trying to redact it. And this is our analysis of the long-standing law, D.C. Circuit case, the Hubbard case, 6 different factors. And except for these pretty minor redactions, and in particular the identification of witnesses' identities, this should be made public. That's going to be total anathema for Trump, who, first of all, has been given a few days to argue redactions for the memo, but an extra 10 days until October 10th about the appendix itself. And that's one way you can know that the appendix is way bigger than is the actual 180-page memo. Also, that's just the sort of way of legal filings. You know, the appendix is sort of all source material, and there can be volumes and volumes. But Trump's whole lookout here, and he's been successful to date, has been to keep any of the explosive evidence that Jack Smith has from being made public. He, wanted not to go to trial for that reason. Then he didn't want to have a mini trial, and for other reasons that mini trial was defeated. But if Chutkan agrees with the DOJ and Jack Smith and basically says, okay, this 180 pages, we're now going to make it public because that's the way it works, and there's a general presumption. And by the way, I think you can expect the media to also come into the fray, and in the person of some very accomplished, fancy white shoe lawyers at big firms. And now Chutkan may hold fine. She'll hear from Trump on the motion by, I think, October 1st. And then it's sort of set up for her to hold, hey, this motion by the DOJ can come out from under seal as long as we have these redactions. That's going to make Trump wig out because it's going to include, it seems clear, summaries of what Mike Pence said in the grand jury, summaries of what Mark Meadows told the special prosecutor. Remember, he cooperated without an immunity agreement. The kind of stuff that is potentially really explosive, gives the public a sense of the most damning evidence against Trump. You could roughly analogize it to what Jim Comey did, the FBI director, in 2016 in October, making characterizations of a Hillary Clinton case that they weren't bringing. This would be legit under the normal process. So if we didn't have Trump versus USA, the immunity case, what would happen here? It would be a fight over what should be redacted according to First Amendment standards. But Trump now is going to play his favorite new legal tool, Trump versus USA, the immunity case, and say, this isn't about just the First Amendment and the people's right to know and Hubbard anymore. This is about immunity. And if this comes out, it just ruins everything. Now, there's nothing about Trump versus USA and the immunity opinion that says the public can't see certain evidence. It happens every day that evidence that a jury can't see, a court decides publicly whether it can come in or not, meaning that the public learns about it. Say there's a search warrant and they challenge the search and they win the challenge. Nevertheless, the information that a jury isn't going to see, the public gets to see. That's just the way adjudication goes. But Trump here has made the argument that the very publicizing of any of this information will, I think his word has been occasion, opprobrium, basically just what would happen theoretically or potentially make him look really bad as a candidate and before the election. So I think he's going to have to try to fight on those grounds, not just simply, well, this could be immune. He needs another extra argument for why it shouldn't be made public in the first place. That would be a step beyond what the court has done on immunity, and it would basically test the principle that they haven't really reached so far of whether or not somehow, because of the unusual circumstances here, and I'm thinking what other courts have said, for example, in the New York case, because of special circumstances, we're going to find that immunity or the immunity principle precludes or is an overlay on what would be the very sort of straightforward First Amendment analysis of what should be redacted. So that's the battle that's coming. And in very practical terms, I think what we should be looking for is whether Trump is able to mount that battle for long enough to get him over the hump of November 5th. And therefore essentially moot the question, will this stuff come out and potentially be politically harmful before the election? So that's the fight that I think is now one step away from being ginned up, but Trump will take that step by the redaction litigation that is following on the heels of the actual submission of the DOJ's brief. So what in the DOJ's brief can be made public, what needs to be redacted, that's where Trump, who has been able to, through a combination of luck and lawyering, forestall anything coming out so far before the election, that's the final battle for him to try to keep stuff from coming out. And it has to involve some attempted broad application of the immunity principle that the Supreme Court announced unwisely in my view, but that's a whole nother YouTube or a whole nother discussion in Trump versus USA. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.